Circuit Court for further resolution.
Yes, Your Honor.
People also.
Thank you, Your Honor.
Your Honor,
This time we wait for more readings and stand mute for the charge.
I would also waive the reading of the information, stand mute.
Defendant having.
Attorney requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple.
Oh, really? Seriously? Okay, cool. Permission to practice is granted.
Thank you, Your Honor. Please state your name for the record.
Terrell Cooper. Thank you.
Your Honor, at this time, we waive my client's right to a preliminary exam.
Is that correct, sir?
Correct.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
And you understand that that means that you'll not have that hearing, that you'll proceed to circuit court for further resolution.
Yeah.
People also waive their right.
That's right.
Preliminary examination having been waived. Sir, turn around.
You ain't got to talk to me like that. I'm gonna turn around.
Turn around, please.
Thank you.
And then having waived formal reading, standing mute, court will enter a not guilty plea. Is that correct, counsel?
Yes, it is.
Pretrial will be set for
July 25th at 1:30 before Judge Slate Thursday.
July 25th, 2024, 1:30, Slate Thursday. Bond continued.
Thank you, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Ms. Harrell. Name for the record?
Rosemary Harrell.
Okay. I have a plea form. Is that what we're doing today?
I'm sorry, Your Honor. Yes, it's my understanding that there's going to be a plea today. We have provided that to the court.
Has she signed a advice of rights form, counsel?
No, Your Honor, I'm so sorry.
Get off your phone and have her sign a form, please.
Will do. Thank you. You're okay. Right here.
Well, they're doing that. The court's understanding of the agreement is that the defendant will be pleading guilty to an added count for of arson. Is that the 5th degree? In the 5th degree. That is a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. Fine could be increased if it depends on the value of the property. That's greater than 2,000 that would become the maximum fine. And upon the defendant's plea to that charge, counts 1, 2, and 3 would be dismissed. And that the defendant to go to mental health court. That is the court's full understanding of the agreement.
That's correct, Your Honor. Thank you.
And that is our understanding, Your Honor.
All right. May I have her sworn? Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Rosemary Harrell.
All right. Ms. Harrell, it is this court's understanding that you are going to be pleading guilty to the charge of arson in the 5th degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine. $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken or destroyed or otherwise injured. If that's greater than $2,000, that would become the maximum fine. You understand?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this matter, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights if you're part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
That's correct.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will. And because you believe that you're indeed guilty of this offense?
yes,
February 23rd, 2024, at the location of 2010 Whitaker Road, in Ypsilanti Township, Washington County, State of Michigan. What did you do that makes you think that you're guilty of this offense?
okay. I attempted to start a fire and I ran in there with a machete.
Okay.
Oh, with
This is at a Kroger, right?
yes.
Okay. What'd you do that makes you think that you're guilty of the charge of arson?
I'm gonna start a fire now
Okay, you tried to start a fire where?
at the Kroger. I tried to start a fire at the Kroger in the liquor section.
Okay, that's what I'm trying to get to. You went in the store. You went to the liquor section. Is that correct?
Yes,
And then you attempted to try to start a fire there.
yes,
Okay. And were you successful in that?
no,
But you attempted to do that and burn property,
yes,
and that property didn't belong to you.
right.
I think I've got everything. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 22nd, 10 a.m. before Judge Washington.
August 22nd, 2024, 10 a.m. before Judge Washington.
Thank you, Your Honor. And if we may, with regard to bond,
Yes.
Your Honor, my client advises that they can stay in Ypsilanti with their mother, willing to do home confinement, willing to do GPS tether, asking for release in light of the fact that they've been accepted in the mental health treatment court. So just asking for
But is she currently receiving treatment at this point?
not at this point, Your Honor, as far as I know, just the acceptance into the mental health treatment court at this time.
All right. I don't need a response. I'm going to deny the motion for bond reduction at this time.
Thank you.
You can take that up with Judge Washington. Thank you. Restore his phone privileges. Okay.
That means is when you revoke my phone privilege, is it to that number or is it to all my family?
I'm sorry.
Because I call my grandmother, my other kids, mothers, and all that. So is it revoking that number?
I get you. I'm just saying that what I'm hearing right now is that you violated a condition of your bond. You're telling me you haven't. I've got this phone number. Your counsel hasn't heard it. So what I'm saying is I am, as an initial position, going to revoke your phone privileges. He'll get the phone messages. He'll be able to get to you. They can get to me. I'm not saying I might not restore them, but at this point, this is what I'm going to do.
Okay.
Okay?
All right.
I'll get on it fast.
If that's you, wave your hand. I don't know who he's talking to.
Mr. Beach, can you please unmute and state your name for the record?
Bobby Beach, BOBBY.
Okay, that's it.
Thank you, Your Honor. We are respectfully requesting an adjournment so I can have a meaningful conversation with my client.
Probable cause conference, August 1st, 2024, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Mr. Beach. You can log off now.
Clerk calls the case.
I'm requesting Michigan Court Rule 8.10 under the supervision of Assistant Public Defender Lamise Saab.
Who are you?
Oh, I'm Alex Parks. I'm
All right, start again.
Good
Tell me
morning.
your name.
Yeah. Good morning, Your Honor. I'm Alex Parks. I'm requesting to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Lamise Saab.
You've not been before me, have you?
I have.
You have?
Once or twice before, yes.
And you forgot to give me your name?
I'm sorry. Yes, Your Honor.
Probably shouldn't let her go then. You forget something that
One second, the guy that's.
I didn't even know who she was. She just came up, started talking to me. It's okay. Permission to practice is granted. Go ahead.
Thank you, Your Honor. Ms. Sedano, can you please state your name for the record?
Simone Sedino, and I have a question. I work third shifts. So is there any
Hold
way
it.
when I
Say,
have the rest,
hold on. You got to slow down for me. What are you trying to tell me?
I work third shift. So is there any way when you reset my court date, it could be 1 p.m. or after? I still need it to be Zoom because I'm Ubering to work. But I've been on Zoom court since 9 this morning after getting off work at 7 this
Okay,
morning.
and I've been here since 8:30. So
You
I
also
can't,
didn't
I've
work
got
till 7 in the
50
morning.
calls. Ma'am, I don't think, you know what? Here's what we'll do. I'm going to adjourn this. She needs to appear in person. Zoom is a privilege.
I don't have a way, so that's not gonna happen.
Oh, it better. I'll come get you.
If I don't have a way,
Preliminary
what are you gonna
probable
do?
cause conference. Probable cause conference is adjourned to August 1st, 2024, 9 a.m. in person. Well, she left. I said what I gotta say.
I'll let her. Thank you.
Okay, and you'll let her know. Those people with the lights show up. That's for her. Court calls the case. People versus Devin Miller.
How are we proceeding?
Your Honor, can I inquire if Miss Ritter is going to be handling this case next time, because I want to be able to communicate with her outside of court, give her additional information about my client, and also there's some additional discovery that I have not been tendered that I need to get.
She's my courtroom prosecutor. I'm not sure what you mean by is she going to be handling it next time? She's the prosecutor.
Yeah, what I'm asking is, well, I want to schedule it for another pretrial, but I want to be able to contact her outside court, give her additional information about my client and about the situation, and be able to get the discovery that I need.
Okay, so, I mean, I think I answered your question, counsel. She's my courtroom prosecutor.
Okay. All right, Your Honor, what I'm asking for today is an adjournment to this is the first pretrial. I'd like another pretrial, and I want to communicate with the prosecutor in the meantime.
The court will continue a not guilty plea on behalf of Mr. Ligon. Set the matter for final pretrial conference. Court will set a final pretrial conference. Oh, Madam Clerk, I don't have it looks like I left my calendar on my desk, so I'm gonna need you to maybe pull up a little bit more, but a court is gonna set a final pretrial conference for Friday, October the 13th at 9:00 a.m. Discovery should be submitted by September the 13th. Bond will continue with no contact with the complaining witness and anything further.
Yeah, Your Honor, if we do have a resolution prior to October 13th, would we be able to get on your docket?
No, if there's a resolution, it'll be resolved on October 13th.
Okay, and there is no date that's sooner. I don't know that we need that much.
I said, no, I need that much time. I need that much time. This is the court's docket. I need that much time. And the people are going to get 2 months to get the discovery to you. And then my docket says October the 13th.
Okay, thank you, Your Honor.
Okay, and then in the future, counsel, when I answer a question, the first time, I answered the question. You keep asking me again.
I'm sorry, Your Honor. I don't mean to be
Okay.
disrespectful to the court. I've never been in front of this court before, so I
So
apologize if I've offended the court in any way.
you didn't offend me. You didn't offend me. I'm bringing it to your attention. You didn't offend me. I said, no, you couldn't come early. Then you said, are you sure? That's basically what you said. Are you sure? I'm not offended. I'm just letting you know.
Okay, thank you, Your Honor.
Okay. All right. Anything further for the record?
Not from the people, Judge. Thank you.
Nothing further, Your Honor.
Okay, then we're all set until October 13th at 9:00 a.m. Have a great day and stay safe.
Thank you, Your Honor. You too.
You're welcome. Thank you. All right, I'm ready on, please.
Hello. My name is Raquan Watts. How you doing, Miss?
I didn't ask you your name yet. Miss Fan, your appearance, please.
Malika Span here on behalf of the defendant, Mr. Watts, who has stated his name for the record.
All right. So Mr. Watts has been returned to my courtroom because he's been kicked out of the specialty court program. I have been informed that Mr. Watts has been violated numerous times, that Mr. Watts refuses to go to treatment, that Mr. Watts continues to walk away from the program, and that he does not want to participate. Ms. Span?
Judge, that is correct. Mr. Watts has had several issues. I believe that the mental health court and that assessment would fit his circumstances much more so than the substance abuse program that he
Oh,
was in.
no, don't let Mr. Watts fool you. That ain't, Mr. Watts was in mental health treatment court. Mental health treatment court is a dual diagnosis court. Judge Holmes is the ultimate expert on specialty courts. Judge Holmes would never have Mr. Watts just somewhere in uh uh drug treatment court when he clearly has mental health issues. No, Mr. Watts has been kicked out of mental health treatment court and he cannot go back. And he is here before this court now for revised sentencing because they have kicked him out of the program and he cannot go back to sobriety court, to mental health court, to veterans court, to community court. He can't go back to none of the specialty courts because they're sick of Mr. Watts walking away and violating, having to be found, having to go to jail. Mr. Watts don't want help. Mr. Watts don't want help. Mr. Watts want to stay on drugs and he want to stay with his mental health issues. He does not want any assistance. Now, another response, Ms. Span?
Well, Mr. Watts would like to start his employment with Burger King. He states that he has had the interview and he looks to work and would like to be released on tether so he could do so.
Mr. Watts is going to get fired from that job on the second day because Mr. Watts is combative and not participating, and he keep walking away. And because he did not let Judge Holmes and her staff address his issues, that's why, and look at him, he getting ready to try to call himself on overtalk me, but I am the queen of not being overtalked. I'm the queen of not being overtalked. So we're not going to do that. I'm going to tell you my intention, and then I will allow you and maybe your client to have a response to my intention. It is my intention to revoke Mr. Watts' probation. I am going to sentence him on case number 224414001 to 93 days in the Wayne County Jail. Case number 224483401 to 93 days in the Wayne County Jail. Case number 224428601, 93 days in the Wayne County Jail. That is my intention, Ms. Span. Anything further?
Judge, I would just like to request that those run concurrently and he be given credit for any time served.
The 3 cases will run concurrently, and unless the law requires it, I'm not going to run them concurrently. But if the law requires it, then they gonna run concurrently. So I guess I better find out. Mr. Watts, you can unmute. You can unmute.
Judge, I was trying to ask you. Yeah, I got a job interview on the way.
You should have thought about that when you kept walking away from the program. You should have thought about that job interview when you kept walking away from the program.
I'm not done. I have not done anything.
Your sentence was to go and participate in mental health treatment court. You have decided that you did not want to do that. Now, what would make me think? What would ever make me think that I was going to be able to do anything with you on probation when you clearly keep walking away from all of the help that we are trying to get you? So that
promise I'll do the help. I
That job
promise.
interview
I'm
is
not on drugs.
wait.
I'm not on drugs. My daddy gave
That's why you were in the mental health court. That's why you.
I know my daddy gave me a phone. I got my ID and social security
Yeah, they
card.
told me that your father came up to the place and brought you a bicycle. They told me your father came up to the place and set a bicycle outside of the treatment place, and you got on the bicycle and rode away. Yeah, I know all about it, Mr. Watts. I know all about it. You ain't coming in here with nothing, no whatever. So anyway, court is going to send that. That is my sentence. I have not changed my mind. And then hopefully one day, Mr. Watts' father and whoever else is around him that is accommodating his refusal to get treatment. Perhaps those people will stop enabling Mr. Watts to remain where he is. I think the father should be charged with something, but that's just me. But that's my order. I'm revoking probation. He is sentenced to 93 days on each count. I do understand that Judge Holmes at some point gave Mr. Watts 45 days in the Wayne County Jail, but that was for a violation. That was for a violation. Those 45 days do not count toward the 93. The 45 days do not count toward the 93. Look like he just knocked down the jail camera. They probably gonna come get him, and then he gonna have another charge because he went inside. Did you see him jump up and then look like he knocked out the jail camera? So the 45 days, he's not getting credit for the 45 days. But if he served any other time outside of the 45 days, then he can get credit for that time.
Thank you, Judge.
You're welcome. I guess they're gonna have to log back Miss Terry on another camera because it looks like Mr. Watts broke their camera. That's what that looked like. Okay.
Oh, okay.
Chantel Phillips, whatever that is on your head, please remove it. Gina Whitfield, please start your camera. Irving, you cannot be in a moving vehicle. You cannot be in a moving vehicle.
I'm not driving though. I still can't be in a moving vehicle.
I don't understand why the people always respond to me and say I'm not driving, as if I can't see what side of the car you're sitting on. So here's the thing I say, you cannot be in a moving vehicle. We are in court and we're not moving in vehicles. So I'm gonna send you, sir, please be, sir, okay, please be quiet at this moment. I'm gonna send you all to a breakout room. I need everyone to accept to join the breakout room. And in order to attend court, you must be stationary, seated in an upright position, ready to attend court. In order to attend court, you must be stationary, seated in an upright position, and ready to attend court. Please accept to join the breakout room and then wait for a lawyer to come into the breakout room to speak with you. Wait for a lawyer to come into the breakout room to speak with you. Ms. Whitfield, you are going to accept to join breakout room number 1.
All right, Leandre Ramon Irving.
Now, that's not going to be able to happen. Now, first of all, you keep moving around and you putting your ear up to this phone. Now, this is really distressing to me.
All right, apologize for that.
It's distressing to me for a number of reasons. This matter is scheduled at 9:10. Mr. Irving has on a white t-shirt that is inappropriate for court. He is putting his ear up to this camera as if this is not at least his 3rd or 4th time appearing to this court. And by the 3rd or 4th time appearing to the court, most certainly Mr. Irving should know proper courtroom etiquette and decorum. But it appears to me that he does not. He has logged on this morning and has been inappropriate at every step. Ms. Stevenson, how are we continue? But in the future, if you had your clients come in with these undershirts on for court, I'm just going to delete them. I'm just going to delete them out.
Yes, Your Honor.
How are we proceeding?
Your Honor, we would continue the matter, continue our jury demand at this point. I think there's a jury trial scheduled for November 28th, Your Honor.
And Ms. Ritter, will the people be ready to proceed? It seems like I must have wanted the people to confirm their witness if the trial isn't until November. You said November what?
28th, Your Honor.
I don't even have that written in my book. I
Oh, okay.
have Boykin 3 cases, but Miss Sealman, can you confirm that Mr. Irving's case is on November 28th?
Second now.
Ms. Ritter, I feel like if I set a final pretrial this early, the people were supposed to confirm the witness. Do you have any information on that?
So Judge, I'm looking at my notes, and the victim advocate's notes. So the complainant witness, who the minor child of Mr. Irving, has not appeared at any pretrial conferences. And it looks like, according to the notes, that we don't have any contact information for the complainant witness. So,
I mean, okay. When the police submitted their information, who did they put down? They didn't put down anybody to say, this who has the child is in the custody of this person right here, and this is their contact information.
well, on the police report, Judge, there is a listed address.
I need the police and everybody to do better. Okay, I need everybody to do better. Okay. So there's an address, but no phone number for an adult who has care, custody, and control over the minor child. Has the OIC or anyone gone out to the address?
No, Judge, there has not been any attempts made to the location, but the phone number we have, Judge, it looks like Victim Advocate Services tried to reach out to that phone number, but they did not get an answer.
Well, let me say this. I quit. I quit on Mr. Irving. I quit. He has to come in person. I quit on him. All right. We're gonna adjourn the case. Mr. Irving has to come in person. Let's see. Monday, July 24th, Mr. Irving has to come in person. And Ms. Ritter, maybe by that time, the OIC or somebody can go out to their house.
Yes, Judge, I'll get in contact with the OIC to make location or to make attempts to the location again, Judge.
In person only, in person, and properly attired. No shorts, no flip-flops, no beater shirts and stuff. A properly attired for court. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Irving at this time. Thank you, Your Honor.
I said, have a great day.
And
Stay
it's
safe.
Stevenson appearing on behalf of Ms. Ayanya Garrett. Ms. Garrett, ma'am, please unmute and tell the judge your full name.
Unmute.
Ayana Garrett.
What's your middle name?
Monet.
Ms. Stevenson.
So I am going to say, Your Honor, that that Ms. Garrett has been working with Dr. Alexander of CARE. She's been doing anger management with him. I think she met with him most recently last week. She would have met with him tomorrow, but for the fact that he asked her to reschedule due to her current physical condition. So I am going to ask the court to continue to work with Ms. Garrett, Your Honor. I know that this has been.
For how long? I'm wore out. I'm wore out.
Yeah.
I mean, I remember Miss Garrett. I remember when she came in person. I remember what she told me. I remember. But listen, sometimes you got to put some skin in the game, and you got you know, we can't, I can't keep doing this. I'm not going to be, let me tell you, it's giving Norman vibes. Okay. That's all I'm telling you. It's giving Norman vibes, and I'm not going to be able to do it. I'm trying to work with Miss Garrett. I'm trying to work with you, but I'm not going to be able to do this. There are some things that no matter what you're going through can be obtained. Sitting up straight, coming to court, having your device, that it doesn't matter what a person is going through, unless they are just, you know, paralyzed and got to lay down. Unless they're on bed rest and got to lay down. It's some stuff that can, I mean, I don't know why you doing that. That's what I'm talking about right there. I didn't ask you to show me your feet, legs, belly, or nothing. A part of your problem is you won't listen. You won't listen. I didn't ask you to prove anything to me. I'm making a statement about the fact of how you have been behaving all day. Whether or not your feet are on the floor, you are leaned forward with your arm to your face. It is inappropriate. It is inappropriate. When you come into the courtroom, you are standing straight up at the podium. Therefore, when you are on Zoom, you should be straight up and ready to attend court. But yet every single time, Ms. Garrett, I have to have this conversation with you, and you do not show any contriteness. You do not show, Judge, I'm trying to do it. Judge, is hard. You always got a smart comeback and all of that, and I'm sick of it. I'm sick of it. I am sick of it. I'm sick of it. So this whole woe is me, and please y'all help me, but you're not cooperating with the help. I'm sick of it. This whole, my grandmother came, or my mother came, I forgot who came. My grandmother came to help me watch the kids. You're sure not showing no appreciation. I'm gonna get it together because they came all the way here to help me. I'm here by myself. Seems like to me, if that's the case, then every time we come on here, it should be smooth sailing. The judge is giving me so much grace and mercy. I'm so thankful. I was going to revoke your probation before, but yet here I am again, giving this same speech to you again. Well, let me tell you something. I'm not going to care about your family more than you do. I'm not going to care about your freedom more than you do. So we might go back to that original statement that you told Ms. McCall that you didn't want to do this and you just want to go to jail. Because guess what? I don't want to do it either. And I just want to send you to jail. So you're either going to come on here with a different attitude, or that's what it's going to be. And you're not going to care and I'm not going to care. And it's just going to be two people not caring. Your client want to speak, Ms. Stevenson.
Yeah, I guess at this point, Your Honor, I think that the best thing for Ms. Garrett would be to prepare for that meeting with Dr. Alexander. And we would ask the court to continue the matter. I believe that based upon my last, okay, actually Ms. Garrett wants to talk. So
yeah, let her talk. Unmute. Let her unmute and talk.
You're saying no.
All I was just saying was the last time that we met, and I'm not making this an ability. Remind you, I kept coming back because I was unable to make those payments the way I was. You were supposed to set up some type of specialty court. No one never, ever reached out to me. I did all the researching that I could and got all the help that I could within an amount of time. But no one never reached out to me from the specialty court. So I never got no assistance.
I want to know what that had to do with Ms. Garrett in the court. Cleaned up.
I'm not hemmed up. I'm on the back of a wall. I'm sitting on the floor. It's not that I'm hemmed up. My body is aching. My back and my body, I have COVID. My body is aching. I'm sitting behind the couch because I can't take the sunlight. Ma'am, I am going through something right now.
Me too.
Me too.
Me too.
Me too.
I'm
And I
really
I really do apologize, and I really do appreciate the chances and the things that you have helped me do and kept giving me chance after chance. It's not that I'm sitting here begging for chances, or I'm saying that I'm unable, or I'm not capable, for which I am able to do everything that you're asking me. And I'm trying, like I said, it was just, I never received the help that you said that you were going to allow me to help. You said that you were going to contact some specialty people. I never got those calls from those people, and I'm not using that as an excuse. I just really would have liked it, the extra help that you would offer me the last time when we were on Zoom.
Miss Stevenson, I mean, I don't know where to go from there.
So in that she does have this relationship set up at this point with Dr. Alexander.
Is she talking about Mr. Patel? I don't know who the specialty people are. So that's what I don't know who the
I
specialty.
don't know, whoever you said that you
I'm
were going
talking
to
to Miss
hook me up with
Stevenson. I'm
before.
talking to Miss Stevenson. Miss Stevenson, did I refer her to the street outreach court?
I don't think
Is
so,
that-
Your Honor. I think it was through whatever resources Ms. McCall would have available. I think that's where we're headed.
Let's just see if we can give Mr. Patel her phone number. Because Grace and Mercy running out. Let's give Mr. Patel. Let's give her Mr. Patel's phone number and give Mr. Patel her phone number. And I have not known Mr. Patel not to contact somebody, but it could be the case, because no situation is perfect, and Mr. Patel could be getting overwhelmed, just like Mr. Rice is overwhelmed probably with all the people that I keep sending now. But let's just make it happen. So I just put her on in February. We got plenty of time. It's just, are we going to be able to take up the plenty of time? All right. Oh, Miss Stevenson, I'm getting ready to send you this. I forgot to send this to you. Remember, it doesn't have anything to do with Miss. I'll tell you after we finish. All right. So when is Miss Garrett gonna come back to me? After I want to give it plenty of time for Mr. Patel to contact her, for her to contact Mr. Patel, and for her to continue to, I think Miss McCall must have referred her to this other person that you're telling me about.
Yes.
All right. Yeah. So let's get it done.
Are we? Oh, we are live. Okay.
Yeah. 90 days. Is
yes,
that
please.
all
Yes,
right?
Your Honor.
90 days. Well, you have her phone number and stuff because she was texting you saying about the
Yes, I do.
situation. So this is July, August, September, October. October, let's come back October want to do the 20th, October 20th or the 13th?
20th, please, Your Honor.
October 20th. And the only specialty people that I think Miss Garrett could be talking about is Mr. Patel. That's the only thing coming to my mind. Otherwise, she would be talking about drug court, sobriety court. And I don't think I was referring Ms. Garrett to sobriety court unless you have some different information.
Oh, I don't. And I know that there was even some, I'm just wondering about the street outreach court because there was some conversation about some type of special assistance, which Ms. Garrett indicated she wanted to work and take care of her family, that she didn't want to have any kind of public assistance or anything like that.
I already have found the job. I'm sorry to cut you off. Miss McCall got me hooked up with some temporary agency. I worked there for 1 week at the zoo, but due to my background, they said that I had to wait until my stuff came back because I had something pending. And when it came back, it was my probation. She said that I needed to get it written off because they really didn't allow people who were still on probation. You had to be either off of paperwork or a felon that already had got just like a closed felon or something, not an open case. You can't be on probation.
So that's probably why we never did send her to the specialty people, because she already had got a job and something else. Let's just connect her with Mr. Patel and let them work that out.
Yep, and I even got proof that I was working as well. I got a pay stub.
All right. October 20th at 10
Okay.
o'clock.
Thank you very much, Your Honor.
You're very welcome. Have a great day. Stay safe. Have